my capacity as Chair of the Health and Social Services Public Safety Committee. No mean feat in many ways in terms of the delivery of our health and social care system. And I think it is important that we reflect on, I suppose, two important policy and legal areas in our discussions today, which very clearly affect vulnerable children. Firstly, looking at the evidence around a child's genetic connections in adoption in areas like donor and surrogacy situations, which all merit greater recognition than they currently tend to receive in law. And I say that based on statistical information around the numbers of our children and young people who are currently in care. And when we look at some of the details around the 1995 order, and now between the 1st of April 2011 and the 31st of March 2014, the number of children looked after has increased by 14% to 2,858. And I know in my own area within the Western Trust, this has been increasing dramatically, and is cause for all of us to look at how we target interventions and legislation accordingly. And it is the case that the majority have been looked after for less than 3 years. A tenth have been looked after for 10 years or longer. So it's a considerable period of time. And it's thought often that the reasons for that increase are linked to, it's often said, greater financial strain on families, increased applications for public law orders after a series of high-profile child deaths from neglect and abuse. Stark realities for us all. And I think recent legal judgments as well clarifying the responsibilities of HSC trusts for homeless young people aged 16 and 17. The profile, and I think this is important as well, of children available for adoption has radically changed from 50 years ago, when babies were almost relinquished by unmarried mothers, as it was said. Adoption has moved towards a permanent option for children who cannot, quite simply, be cared for by their parents. And in the interim, many children are taken into care in order to protect them from significant harm. So the profile, if you like, of children who are being looked after has dramatically changed. There are very few healthy babies who need adoption in the north of Ireland today, and there are usually slightly older children in the care system, often with health or emotional difficulties incurred through, again, not nice, but a background of abuse or neglect, something that all of us should be aware of. During the year ending the 31st of March 14, 89 children were adopted from care in the north of Ireland, and the average age of children at that time was 4 years and 4 months. There are two particular facts, I think, that highlight the importance of these issues that are being reflected on today. And I think, firstly, it's known that the life outcomes for children who spend long periods in care are poor compared to their peers outside the care system. And secondly, children in care, or those adopted generally, know their birth families, and it's important in many cases that they continue to have that contact with them. The application process, I'm sure there will be discussion around this, for prospective adopters in Scotland, England and Wales is similar to that here in the north of Ireland. However, and it is important to reflect on the legislation in those jurisdictions and also in the 26 counties has been updated recently. And here is the thorn in our side, in my view. Proposals to modernise that law in the north were presented to the department, adopting the future review in 2006 with 21 recommendations, including and this is, in my view, the bugbear, that unmarried and same-sex couples be allowed to adopt. That particular issue has been contested by some sections of the community, and it's resulted, in my view, in an unfair impasse in adoption reform that has also seen the Minister for Health being judicially reviewed. Nevertheless, last May, when officials briefed our committee, they told us that the bill would need to be introduced in the Assembly by early March 2015 at the latest, if it's to become law by March 2016. It's now early March 2015. And as the bill is principally intended to modernise the legal framework for adoption and place children's welfare at the centre of adoption decision-making processes, the fact that it has not yet been introduced should be a cause for concern for all of us in society. And we also know that the Department, along with the Department of Justice, intends in the very near future to commence a care proceedings pilot, and the outcome of this may suggest the need for further legislative change. The committee stage, and I throw this offer out to yourselves, the committee stage of this process will provide an opportunity not only for the committee but for wider civic society to allow for careful consideration of the legislation. And I do suggest to yourselves in this room and in other rooms to utilise that opportunity when it comes in front of us. I am sure some of the research discussed by our speakers today will be relevant to the committee's observations and recommendations. That's my thoughts. We have an increasingly expanding growth of our children and young people who are looked after. We need the legislative reform to ensure that we have the efficient, robust processes in place to meet in a safe way that ever-increasing need, in a way that actually puts the child and young person at centre. And it should not be that any proposed legislation or bill going forward is being delayed, held up by particular views and indeed prejudices, in my view. We need to move this bill on as a matter of urgency, and certainly my door and the door of the committee will be open to doing what we can do in relation to that. So the first of our speakers today is Dr. Alice Diver, who I know, and it's great to see you up here, Alice, who will discuss a child's right to genetic ancestry as a key element of the best interest principle in adoption, donor and surrogacy. We will then hear from Professor Bridget Featherstone, Open University, and Dr. John Devaney, Queen's University, regarding making timely decisions, and I think this is important as well, for vulnerable children to ensure that they do not remain too long in neglectful situations, but also, I think, increasingly important, providing the opportunities for the families to demonstrate how they can actually meet children's needs. So thank you very much. I hope that was of some use. My door is certainly open. Critically important topic that you're addressing today. The findings of this will be shared with the committee, and I wish you a very productive session. I have to go to chair the committee, but wish you every success in terms of the outcomes from this today. Thank you.
Good afternoon. Could I just start off briefly just thanking the organisers for allowing me to present the research from Ulster on blood ties. I have to thank Tina and apologise. There's a couple of extra slides that I added in this morning as well. So if people email me, I can send out the extra stuff. It's just maybe a bit of extra reading, but I know it's the last thing you want when you have the slides posted up to have a lunatic adding in extra stuff. So I apologise for that in advance. Can I preface the talk just by saying that I'm not anti-adoption. Some of the case law might make it look like I am, and I'm not. The research doesn't argue for blood ties to be this paramount consideration. Within the research, there's an entire chapter devoted to cases where the blood tie was preserved at all costs and made paramount, and best interests was just of the child was simply not served by that at all. You might be familiar with the Baby Ann case in Ireland, Baby Veronica case in the States. Cultural heritage, parental rights were used as the key factors, and best interest was just completely sidelined. I can get this to work. So that's, you know, I don't want it to seem like I'm knocking social workers or knocking adoption, because I might as well put it out. I am an adopted person, and I did spend 7 months in care, so I don't want to be ungrateful. What the research does aim to do, what it tries to highlight, is really the difficult nature of legislating in this area. There is a bit of a birthplace lottery in that depending on where you're born, you may or may not get your original birth certificate. Again, thank you, Quebec. And again, that's why I'm slightly disillusioned. Donor anonymity, again, Northern Ireland is quite good, and the birth certificates are generally available, and donor anonymity has been done away with. But in other countries, the situation is not as good. As the Strasbourg court keeps saying, there's no social consensus on this. So therefore, we should just leave it up to the individual countries. And again, what the research will do will flag up what happens when that happens. What are the issues that are going to court? What good things can you draw from the court cases, and what bad things can you look out for? How is it relevant to international surrogacy and to donor children and international adoption? Well, as Hames predicted in the 80s, there is overlap. Please don't repeat the mistakes of classic adoption with closed records and with secrecy and silence and the ignoring of psychological aspects. You know, basically saying, please not to do that. Some of the cases will look at the impact of immigration laws on donor and surrogate kids coming in, DNA testing, and how the law is pretty, sometimes, in disarray. Other cases mention that hospitals in England are coming up with individual ad hoc protocols on dealing with domestic surrogacy cases. Not to say that those policies might not be very good, but I wonder, would it be better to have a unified approach across the board? And a recent Irish case is of note. I think it would be worth looking at in detail. You probably have heard about it. It made the news. Basically, the Supreme Court overturned the High Court in their redefining of legal motherhood. It's significant because they glanced across at the 2008 Human Fertilization Embryology Act. They mentioned that they said we're not entirely persuaded by its provisions. They're not entirely satisfactory. They may have used the words legal fiction. They said, how can a child legally have two mothers and no father? Is that satisfactory? What they also said, no pressure on the lawmakers, what they said was it's Parliament's job to change the law, if you're going to change the law on defining legal parenthood, here motherhood specifically. And as you know, the lawmakers in the South, originally surrogacy was in the Child and Families Bill, and then it seems to have come out. It'll be dealt with at a later date. Another significant development, which you're probably familiar with, Fergus Ryan's Adoption and Identity Bill. I was nervous when I pored over it a little last week on the train, scared the man beside me. I was slightly worried. It talked about balancing parental privacy. I thought, oh, please don't do the Quebec thing. Please don't give a maternal veto. I think it's a cruel thing. I would have to say I thought it was great. A lovely piece of legislation. It allows for records to be opened. People will get their birth certificates. There's confidential intermediary happening. If a birth mother decides she doesn't want contact, that's in there, but it doesn't stop the child from getting the birth certificate. I thought that's probably as good as you're going to get. The other thing that I thought was interesting, I think this is probably the most relevant thing maybe for Northern Ireland lawmakers, there's provision in the Act for birth parents to find out about the child they relinquished or had removed when they're 18, and yet the child has a right of veto to say, I don't want that contact. I don't know if there's provision for the child to maybe change, I'm going to say child, you're over 18, so child's a misnomer. I don't know if there's provision for them to maybe change their mind later, because what makes sense at 20 mightn't make sense at 50, I'm discovering, unfortunately. How is this relevant to donor and surrogacy children? Well, some of the language is the same. The issues from the child's point of view can largely be the same. The reason why I've included some literature on this is to just give background to it, that it's not just me with an axe to grind. There's been quite a lot written on the sociology of kinship attachments. De facto customary adoptions are very, very interesting to look at. The psychological stuff is maybe a bit more negative. We talk about, the abandonment and non-attachment. There's no way you're going to, I know, it's like the opticians, and I apologize for that, but I can send these out, and if anybody wants the articles, just let me know. But maybe some of the most interesting or most relevant stuff to look at. Eric Blythe is in there. He has basically looked at the Children's Convention to see what is in there that will help donor children get information, and he finds that it falls short. Bainham talks about legal fictions, biological truths, removing babies at birth. Miller's work is good, makes a point about defining best interests, warns against defining best interests as financial and material gain, says don't forget about the psychology. Hill's work talks about therapeutic parenting. I thought that was interesting. It's a bit, I don't want to paraphrase too much, a bit like saying if you're parenting an adoptee, or possibly a donor child, should you take a therapeutic approach and assume that it's just going to be a little bit different and you're going to have to maybe cope with that? So I thought those were interesting. If you want to look at Canadian or American stuff, Baldassi and Wagar talk about cultural heritage, they talk about kinship. They're all interesting. And as I said before, Hames flagged this up in the 80s. Please don't repeat the mistake. You will find in the court cases too, they sometimes draw upon each other. If they find a legislative gap or they can't find a precedent and it's a surrogacy case, they will quite often look to an English case, to an adoption case. Canadian court, but you can't wait for that. I'm going to mention what the British Columbia court did. They looked at Ray Rose, they looked at an English case in trying to decide about opening donor records. Okay, I'll leave that behind. In terms of international law, that's in there as well. The committee guidance, country reports, makes for an interesting read. You will find things that the Committee on the Rights of the Child, things that they particularly have highlighted as not being good practice or as giving cause for concern. Austria with the baby nests, the anonymous birth systems, Luxembourg, San Marino, France, they're scared of France, Italy, illegitimate children being discriminated against. You've got Haiti. These are sort of fairly recent reports. The day of discussion from 2005 was worth looking at. It was entitled Children Without Parental Care. That was the theme. They immediately said, well, we're not going to look at adoption. It scares people. They said, well, we won't specifically look at that. We'll leave it up to the individual countries. They again flagged up child poverty. They said, please don't let that be the top factor in a decision to remove a child. It shouldn't be the sole thing. Other things need to be looked at. They expressed concern that was happening in some cases. They were encouraged by the development of fostering, kafala doctrine, special guardianship orders. They thought, that these were things to be commended, things to look at. In terms, again, of the case law, what bits of international law are appearing? Article 8, obviously, in family life. That's going to make an appearance. Article 6, fair hearing and procedural matters, is appearing again and again. Examples, pre-hearing agreements, pre-hearing meetings, are parents represented when they agree to a freeing order, placement order. Post-adoption contact can be in there as well. Recent English case, Article 3 was mentioned. It's not a nice case. It was Ray Kay from 2011. Two brothers who were freed in childhood, never ever placed. They went to, I think it was something like, there were 43 LAC reviews. They were abused by some of their foster carers. It's a high court case, but the fact that the court, they don't normally look to Article 3 and use words like degrading treatment. So that's, an utterly depressing case to look at. And again, things like this are rare, but the hard cases might make bad law, but they make for important reading. I think they need to be looked at. The Strasbourg case law is probably at the heart of the research. It's probably the big thing to look at. I won't go through all of the cases because you will lose the will to live, but I'll go through one or two of them that maybe just are worth mentioning, things that came out of them. Anayo against Germany. Strange case. You have a genetic father, unmarried, brought a contact application. The mother was married to another man, so the legal father was her husband. He was deported. The genetic father was deported. He argued for contact. It was Article 8 case. And what the court said, which was interesting and a bit of a departure from from the norm. He said, it's interesting, this father had no way of ever applying to be the legal father, so his fatherhood's not going to be recognized. They then, in some detail, talk about the best interests of the child. They talk about identity, and they tie it to contact. So it's an interesting one. They made a few other interesting observations. They said, rather than having to talk about existing family ties, demonstrable relatedness, they said there's a potential here for relatedness, despite the fact it's genetic stranger, but there's a potential there, and again tied it to best interests. They mentioned that the domestic law doesn't place any requirement on parents to factor in best interests if they are refusing contact with another party. I thought that was, again, worth noting, and if you want the cases, I could send them to you, but they're out there if you want to get them. The R&H against the UK, again, decision-making involving parents, these were issues that were flagged up. They did come down in the end and say, in respect of freeing a child, the benefits of adoption outweigh those of contact. So that's fairly unequivocal. They did stress the exceptional nature of severing family ties, I will say that. The dissenting opinions, always worth looking at. Occasionally today's dissent could become tomorrow's guiding principle or maybe appearing in law. They talked about the need to look at the child's, not just their present, but their future, take that all into account. Best interests can change at different points in time. They talked about foster care being very different to adoption, but they didn't go into a lot of detail in that. The key questions seem to be the purpose of a freeing order or a placement order. Is it to protect the child's best interests, or is it to help in the search for prospective adopters? What really underpinned it? Was it to make the child more attractive to adopters, which is an interesting way of looking at things. The YC case, again, the court starts to use language like preserve and rebuild. And it says, don't forget positive obligation. This remains. The courts, or legislators, the state, they should be, social services should be bearing this in mind. Severing family ties is very exceptional. What happened here was the mother was not assessed on the basis of the need to avoid delay, and the court wasn't overly happy about that. The previous case, I forgot to mention in R&H against the UK, I think I forgot to mention it. I won't say where it began, where it came from, but the interesting thing about it was, come back into my head, so I need to tell you. Parents had their child freed and placed for adoption. A few years later, they moved to a different trust area and were okayed to be foster parents. So the court said, how can this be? This is very odd. I just wanted to add that in, came back into my head. Okay, the other thing about the YC case that the court said, there were some unorthodox aspects to the placement, to the process. So again, Article 6 came in. The child was 8 when things happened, though the mother had mental illness issues. He did take a pop in the dissent at the Strasbourg court, and he said, do not let the margin of appreciation doctrine, where they say, well, leave it up. That's one for private law, that's one for domestic lawmakers, domestic courts. He said, please don't absolve yourselves of a duty to oversee and have oversight of what's happening with member states. So he was probably off the Christmas card list. The Anayo case has been pulled back a wee bit by the Arons case. Here you have a father wanting a paternity test to be done, and the court said no. And they said, oh, totally different to the Anayo case. You're not looking for contact, you're trying to change the child's birth status. So it sort of pulled back, if you like, from the brink. The SH case, interesting for a few points. This was a case involving parents who wanted IVF treatment and were denied it. The issue of their Article 8 claim, that at the center of it was the emotional distress they had to go through at having to settle for adopting a child. The court talked about human dignity and stressed that no matter how a child enters your family, be it adoption, surrogacy, donation, please bear in mind the human dignity of that child is the main thing. Urged member states to keep law under review, especially in relation to donor and surrogacy. The dissenting opinion, that's where they hide the good stuff, said really we don't have a right to conceive at any cost. They did look to international covenants, which is unusual, and hailed scientific progress and advancement. They said this is a good thing which we will benefit from, but don't lose the human dignity in the process. I wanted to get on. Am I okay for time? The domestic case law. Yeah, I've told you about the horrible one of Ray K. The Ray G one made the news headlines. You may have spotted it a year or so ago. This was an agreement between a lesbian couple and their friend who agreed to be a sperm donor. And it all went very well. It was fine. There was contact. It was really amicable, domestic agreement. One aspect the court highlighted, a solicitor firm charged money for drawing up the agreement. That's illegal. That nearly turned it into commercial surrogacy. So the solicitors are getting told off in the court case, if you maybe want to have a read at that. It all went wrong. Legally, the child had two mothers. Father, again, they said things like genetic stranger. But the court, it's only a high court case, the court gave him leave to apply for contact. They didn't order him contact, but they said, we'll allow you leave to apply. And again, they tied it to the child's best interest. They cited cultural and heritage factors, and again, trying to get back to a domestic agreement rather than sort of taking it through the courts. The Ray G. at child case, another sort of strange one. In this, the balancing exercise gets discussed. The welfare checklist, the court said they really hadn't made it explicit enough that the lower court had checked through that. They said in terms of either or, of saying, should we have a placement order or not, they said no, give equal consideration to all the possible factors and all the possible outcomes. Stress as well in doing this, focus on the risks of separating siblings, not least, and to look for that. They say again, last resort to sever families. The Irish Supreme Court, I've already mentioned that one at the start. I wanted to tell you about the Pratton case, Canadian case. This was class action. Children of anonymous sperm donors wanted to get their records. They wanted to find out who their genetic fathers were. And the court took sort of an unusual approach. Discrimination was the heading they brought it under. The applicants said, you allow adoptees, you opened records for them. We're in the same boat, please open records for us. The court made a few points on that, and they said, well now, I think it was something along the lines of, we all know adoptees are sort of special and they have issues. Well, okay, thanks. So they came out and said that. You don't see it too often. They hadn't kept the records. This came out through the course of the trial. So even if they'd won, there wasn't really an awful lot that they could do. They heard arguments on what was happening in other jurisdictions. So the Ray Rose case, an English case, they listened to that. It's really the case that, I guess, led to donor anonymity being overturned. They looked at that and they said, European Convention, they called it, they didn't say a little regional instrument, but they still said it's a regional document. We're not overly persuaded by it. Right, okay, don't tell Strasbourg, they'll get annoyed by that. They said Article 8 is well and good, but no, for us, we're going to look at Article 5. You won't hear a lot about Article 5 in family law. It's liberty of person, security of the person, deprivation of freedom. They looked at Article 5. And when they did their balancing, they talked in terms of privacy, parental privacy, and they used that to justify the discrimination. It was nice to hear that adoptees are special. I'll give them that much. That was something I guess take comfort where we find it. I'm trying to think, are there any other scary cases that I needed to give you? I guess if you want the point of the research, to sort of mainly sum it up, things that I've mentioned these already, what I would urge you to look at. I really do like Fergus Ryan's bill. I wish he would send it to Quebec if he's listening, trying and convince them. The birth parental contact aspect, maybe that could be something. I know the bill doesn't really talk about siblings, and again, how's that going to pan out if you've got finite resources? Grasping the nettle of surrogacy abroad, again, a lot of governments are just a little bit too scared to go there and try to legislate on it. It's an unenviable task as well. Best interest, I think it needs to be basically said again and again. And maybe if a move away from the notion of intention and consent and signed forms as underpinning parenthood, I think it tends to sometimes see the child as a product, and we know that that's not a good thing. So again, for legislators, just keep chanting the best interests mantra possibly. And that's basically it. I might pop up again if I remember another case, because I think I had a scary one that I left out, but I don't want to depress you too much. Thank you for listening.